welcome our development partners. You can see Dr. Kasia there. We are gesture to the public about the Benedicto Kiwanuka Memorial Lecture and Function, which is held every year at the High Court. They will be joining us in tent, and we shall allow every one of us to settle down, and after which we shall be able to receive the Honorable, the Chief Guest. Honorable Chief Justice, the Deputy Justice, the Honorable the Principal Judge, the Honorable Keynote Speaker, the Chief Registrar, and the Honorable Permanent Secretary leading the team will be taking their seats. You are most welcome, Honorable Chief Justice. You will be led to your seats. You're welcome, Honorable Deputy Chief Justice and Honorable PJ, the Honorable Chief Registrar, and the judges are also joining us to take their seats. Protocol, let us give them their seats. Just allow the registrars and the members of the bar to take their seats also. Ladies and gentlemen, we may be taking our seats in the meantime. Thank you. We would like to welcome you once again to this occasion. We shall be allowing the prisons band to also take their seats behind as we wait for the chief guest. You are most welcome once again. I will request DJ to give us some simple Welcome, Bamwine. Politely, can you join the team? And we receive the Honorable Chief Guest. Thank you. Thank you. Retired but not tired. Thank you. Chief Guest is coming and top management. As we still stand, let me invite the very Reverend Monsignor Kasivante to come and give us an opening prayer. Thank you.
I shall begin with a prayer of Solomon from the Book of Wisdom. God of our fathers, Lord of mercy, you who have made all things by your word, and in your wisdom have established man to rule the creatures produced by you, to govern the world in holiness and justice, and to render judgment in integrity of heart. Give me wisdom, the attendant at your throne, and reject me not from among your children. For I am your servant, the son of your handmaid, a man weak and short-lived, and lacking in comprehension of judgment and of laws. Indeed, though one be perfect among the sons of men, if wisdom, who comes from you, be not with him, he shall be held in no esteem. You have chosen me king over your people, and magistrate for your sons and daughters. You have bid me build a temple on your holy mountain, and on an altar in the city that is your dwelling place, a copy of the holy tabernacle which you had established from of old. Now with you is wisdom, who knows your works and was present when you made the world, who understands what is pleasing in your eyes and what is conformable with your commands. Send her forth from your holy heaven, and from glorious thrones dispatch her, that she may be with me and work with me, that I may know what is your pleasure. For she knows and understands all things, and will guide me discreetly in my affairs, and safeguard me by her glory. Thus my deeds will be acceptable, and I shall judge your people justly, and be worthy of my Father's throne. For what man knows God counsels, or who can conceive what our Lord intends? For the deliberations of mortals are timid, and unsure are our plans. For the corruptible body burdens the soul, and the earthen shelter weighs down the mind that has many concerns. And the scarce do we guess the things of earth, and what is within our grasp we find with difficulty. But when things are in heaven, who can search them out? Or whoever know your counsels, except you had given wisdom and sent your Holy Spirit from on high. And thus were the path of those on earth made straight, and man learned what your pleasure, and were saved by wisdom. Let us pray. God, our loving Father, we thank you for this day and for bringing us together for this meeting to remember your servant, Benedicto Kiwanuka. We thank you for giving him to this country and for what he is in this country, especially to the judiciary. May this gathering heighten the consciousness of everyone here present to desire to honor you and respect your commandments. The love of you, God our Father, is reflected in the love and respect of what you created, especially the people you created in your own image. May we love one another in our country and respect all that sustains the human life. Instill in us the respect of your name and all that you command, through Christ our Lord. Amen.
Thank you very much. The Lord's, may we take notice. The Lord is good all the time. My Lord, Honorable Chief Justice, allow me briefly take us through the simple program of the day before I invite the Honorable Chief Registrar. We are done with the prayers. We shall next have welcome remarks from the Honorable Deputy Chief Justice and Chairperson of the Organizing Committee, after which we shall then have remarks by the President of the Uganda Law Society, shall be followed by remarks by the Honorable Minister of Justice and Constitutional Affairs, and followed by a keynote address by the retired Justice of the Supreme Court, Honorable Justice Dawson Tumwesche. That shall be followed by a citation of our D by the Honorable Principal Judge. Next shall be the presentation of the Chief Justice Benedicto Kiwanuka Award 2023 by His Excellency the President of Uganda, the Chief Guest. Then we shall have remarks by the awardee or the representative. We shall have a speech by the Honorable Chief Justice of Uganda, followed by the address by His Excellency the President of the Republic of Uganda by the Chief Guest, present now with us. And we shall have anthems in reverse order. We shall then be followed with a photo session and a reception thereafter, and departure and leisure. At this juncture, allow me invite the Honorable Chief Registrar to come forward and address you. Thank you.
Thank you very much, Your Worship, Eremie. Our Chief Guest, you're most welcome to the Judiciary Headquarters. And we thank you for representing His Excellency. I will be beginning by laying a protocol which I will advise and request that most of the speakers can adopt so that we can save a bit of time. The representative of His Excellency, the President of the Republic of Uganda, my Lord, the Honorable the Chief Justice, my Lord, the Honorable the Chief Justices Emeritus, my Lord, the Honorable the Deputy Chief Justice, the Honorable Ministers present, my Lord, the Honorable the Principal Judge, my Lord, the Honorable the Principal Judge Emeritus, my Lords, the Justices and Judges of the Courts of Judicature, both serving and retired, my Lord, the Keynote Speaker, Your Excellencies, the Ambassadors, the Honorable Members of Parliament present, the representative of the Archbishop, the family of Chief Justice Benedicto Kiwanuka, the Director of Public Prosecutions, the Inspector General of Government, the heads of commissions and statutory bodies present, members of constitutional commissions present, the permanent secretary and secretary to the judiciary, the development partners present with us, Your Worships, the registrars and magistrates and the senior administrators of the judiciary, the president of the Uganda Law Society and the past presidents, the senior counsel, and all distinguished members of the bar, members of the Fourth Estate, the distinguished guests both present and online, ladies and gentlemen, good morning. I welcome you very warmly to the 6th Benedicto Kiwanuka Memorial Lecture. This is an annual event by the judiciary where we commemorate the life of Chief Justice Benedicto Kiwanuka. Our theme this year is Benedicto Kiwanuka, Enhancing Judicial Accountability, Transparency, and the Rule of Law. Our chief guest, Sarah Langasiu, is my name. I'm the Chief Registrar and the Master of Ceremonies for this event. And I will be assisted by His Worship, James Eremie, who was here before. He's a registrar in charge of the Magistrates' Affairs and Data Management, but he is also the Judiciary Public Relations Officer. He has taken us through the program. We have received the overview. And just before we begin the remarks, allow me, our dear chief guest, to just begin a few introductions. We shall do them in phases. But let me introduce to you the dignitaries that have graced this occasion, and then I will come back to do another set after this one. We have with us the Honorable the Chief Justice, the Honorable Alphonse Tigamoyo Windolo. My Lord, you're most welcome, and thank you so much for leading us through the procession. With us, we also have two Chief Justices Emeritus, and it's an honor to have all of you, my lords, here. We have the Honorable Justice Bart Katurebe. My Lord, you're most welcome. It is good to see you again. And we also have the Honorable Justice Benjamin Odoki. I think we all agree that it's beautiful to have three Chief Justices in one room. We can clap that. Thank you so much. With us, we also have the Honorable, the Deputy Chief Justice, the Honorable Justice Richard Butera. My Lord, you're so most welcome. Thank you so much for being part of this. We have Honorable Ministers. With us, we have the Honorable Gedudu Madwali Dominic, Minister of State for the Elderly. He is representing the Minister of Gender, Labor, and Social Development. Our Chief Guest and my Lord Chief Justice, we are expecting the Honorable Deputy Attorney General, who will be representing the Minister of Justice and Constitutional Affairs. He had a small hiccup that has delayed him, but he assured me that is on the way. Our Chief Guest, we also have the Principal Judge. We have the Honorable Dr. Justice Zeija Flavian, the Principal Judge. And again, we are blessed to also have Principal Judge Emeritus, Dr. Yoroka Mbamwine. Let us clap for them as well in a special way. Our chief guest, we have justices and judges. I'll begin with those serving, and later I'll introduce those who are retired. And our chief guest here, we agreed that we no longer use the term retired, but we use refired. And so they are refired and they have a lot of energy with them. We have from the Supreme Court, we have the Honorable Lady Justice Faith Monda. She's wearing two hats this morning. She is in her capacity as Justice of the Supreme Court, but also sitting in for the chairperson of the Judicial Service Commission, where she is the vice chairperson. Thank you so much, my Lord. Our keynote speaker is a retired justice. Let me honor him with that early introduction. My Lord Justice Jotham Tumwesije, it is good to see you retired, and you're most welcome. Thank you. Court of Appeal is represented, the black robes, my lords. We have the Justice Geoffrey Kiabuye, we have Lady Justice Mugenyi, and we have Justice Oscar Chihika. You're most welcome, my lords. The High Court is well represented. My lords, you'll allow me to recognize you as a group. And our chief guest, the judges in the red robes, those are the judges of the High Court. My lords, you're very most welcome. Allow me to single out one, the head judge of the Industrial Court. We have an Industrial Court, Lady Justice Linda Tumusime. Our chief guest, we have the Secretary to the Judiciary, that is Dr. Pius Bigirimana, just behind you. You're welcome. And you will allow me to come back and continue with the introductions, but I have a special recognition. Our chief guest and my Lord, the Chief Justice, Dr. Sababuturo was the first guest to come. So allow me to recognize him with that special honor of very good time management. Thank you, and thank you so much. So we will now start the program, and then I'll come back to make further introductions. At this juncture, I welcome the Honorable, the Deputy Chief Justice, who has also been the chairperson of the organizing committee, to make welcome remarks. You're welcome.
the Right Honorable Dr. Ruhakana Rugunda, Special Envoy of His Excellency the President, the Honorable the Chief Justice of the Republic of Uganda, I adopt the protocol as guided by the Chief Registrar. I welcome Honorable Dr. Ruhakana Rugunda, our guest of honor representing His Excellency the President of the Republic of Uganda, to the Judiciary Headquarters. I thank you, Right Honorable, for gracing this important occasion in the life of the judiciary. I welcome all our visitors on this memorable day in honor of the late Benedicto Kiwanuka. The late Benedicto Kiwanuka was the first Ugandan to be appointed Chief Justice. On 21st September 1972, he was violently kidnapped from his chambers in this very high court building. He was murdered by the Amin regime. The Chief Justice and all judges are enjoined to ensure that human rights and freedoms of individuals and groups are respected, upheld, and promoted by all persons, including organs and agencies of government. They should ensure that all persons are equally treated before or under the law. The judges should see to it that citizens enjoy equal protection of the law. They ought to guarantee that no person is discriminated against on the grounds of sex, race, color, ethnic origin, tribe, birth, creed or religion, social or economic standing, political opinion, or disability. Judges have a duty to safeguard the fundamental and other rights of citizens. In performing duties entrusted to judges, they should administer justice in accordance with the laws of Uganda without fear or favor, affection or ill will. This is all that Justice Benedicto Kiwanuka stood for. That is what we all stand for as justices and judges. The murder by the state of a Chief Justice was contrary to what we are committed to. We commemorate the occasion of the murder of Benedicto Kiwanuka in remembrance of the terrible incident at the Judiciary Headquarters. We commemorate the occasion in the hope that it is never repeated. The judiciary has found it proper to remember and celebrate the life and contributions of Benedicto Kiwanuka every year. On this occasion, our theme is enhancing judicial accountability, transparency, and the rule of law, which should help us to reflect on our past, appreciate the present, and be prepared for the future in regard to promoting human rights, safeguarding and promoting the rule of law. Democracy and human rights are inseparable. The two are indivisible and interdependent with the independence of the judiciary. An independent judiciary benefits us all. We require strong and independent justice institutions to foster and enforce the rule of law. We are grateful to those who have ensured that the tenets of independence of the judiciary are enshrined in the Constitution and the laws of this country. We recognize and appreciate all those who have supported us in the realization of the vision, mission, and values of the judiciary. As an independent judiciary, we stand accountable to the law. We shall always promote and protect the principles of supremacy of the Constitution. We nurture and promote an independent judiciary that delivers justice to the people in a fair, speedy, and impartial manner, as commanded by Article 28, Clause 1 of the Constitution. In performance of its duties and in offering the judicial service to the population, the judiciary cannot successfully operate in isolation from other organs of the state. Article 128, Clause 3 of the Constitution of the Republic of Uganda enjoins all organs and agencies of the state to accord to the courts such assistance as may be required to ensure the effectiveness of the courts. We thank the executive and the legislature for continued support to the judiciary in our efforts to effectively and efficiently execute the judiciary's constitutional mandate, which is the administration of justice to all. Our human and financial resources have been enhanced over time. This has greatly improved our performance. We are optimistic that more resources will be allocated to the judiciary. We are grateful to the other two arms of government for the support that the judiciary has received in this regard. We have utilized these resources to ensure that justice is administered to all in a fair and timely manner. We appeal to all the citizens of this country to render the judiciary and all other institutions in the administration of justice program the necessary support towards the building of a transparent and accountable judiciary that will guarantee to all persons the enjoyment of human rights and freedoms, foster the rule of law, and contribute to the socio-economic development of Uganda. I take this opportunity to extend my sincere gratitude to the Right Honorable Dr. Ruhakana Rugunda for gracing this occasion. We are humbled and do not take this for granted. I thank the Honorable the Chief Justice, who has consistently ensured that this day continues to be celebrated annually. I wish to thank the organizing committee for their efforts in ensuring that this day and this occasion is successful. May I request members of the organizing committees to stand up for recognition. The Chief Registrar, thank you very much for your hard work. I thank you all for listening to me, for God and my country.
Thank you so much, my Lord, the Honorable, the Deputy Chief Justice. Let us add him another round of applause because he has organized so many of this event. And my Lord, thank you so much. Our dear guest of honor, one of the special things about our meetings is that they never take an hour. They start, if it is 2, if you are there, after 5 minutes, you'll find when the prayers have been said and the chairperson is concluding his remarks. My Lord, thank you so much for chairing these committees. And now, before we go to the next, my Lord, allow me to introduce another set of guests that we have. I said I would come back with the retired justices. We have Honorable Justice Paul Mugamba, retired Justice of the Supreme Court. My Lord, you're welcome. We also have the Honorable Justice Remi Kasule, retired Justice of the Court of Appeal, and is also a member who before his retirement was always on the organizing committee. I must say, when the issue of awards came up, he led the first committee on the awards that are given on this day. Thank you so much, my Lord. We also from the Law Society, we have the President, Bernard Owundo. You're most welcome. We have a number of Senior Counsel, Fiona Wall. Yes, you're most welcome. We also have Senior Counsel Simon Peter Chinobe. You're very most welcome, and Senior Counsel James Mukasa Seugenyi. Thank you so much, Senior Counsel, for gracing this event. Representing the IGP, we have Madam Christine Nadine, right behind you. You're most welcome. Thank you so much. We also have from the Judicial Service Commission, representing the Secretary there, Mr. Samuel Mugizi. You're most welcome. Thank you for coming. We have from the Law Council, the Secretary Law Council, Ms. Nabakoza Margaret. You're very most welcome. Thank you for coming. Commissioner of Prisons, we have Ms. Natukunda Ario. You're most welcome. She's representing the Commissioner General. From the Leadership Code Tribunal, we have the Deputy Chairperson, Mr. Asuman Chiyinji, representing the Chairperson. You're most welcome. From the Office of the President, we have Mr. Nisima Emmanuel. You're very most welcome. Thank you for coming. The Chairperson of the Law Reform Commission is here, Dr. Pamela Aliejira. Thank you so much for coming. From URSB, that is the Registration Services Bureau, we have my classmate, Miss Mercy. You know where I come from, that name can make me, but the good thing, that name is easy for other people. We have Mr. Canon Sam Wairagala coming in from Governance and Security. Yes, and we also have Miss Rachel Odoi Musoke, also from Governance and Security. You're most welcome. Dr. Katia, we have you from the head of Mission Austria Embassy. You're very welcome. We have Miss Barbara Kiley, the country director of IDLO. You're most welcome. We have Ode de Jong from Netherlands. You're most welcome. I believe I tried with that one. We have Nicholas Gonze from the EU. You're most welcome. Together with Mr. Paul Otim, also from the EU. You're very, very most welcome. We also have Miss Diva Mukisa, the head of programs from the UNODC. You're most welcome. We have Martha Agaba from Governance and Peace. She's the Governance and Peace Officer from UNDP. You're most welcome. And then we have Dr. David Maina, the team leader of Governance and Peace Strengthening under the UNDP. Our chief guest and my lord, the Honorable the Chief Justice, we also have two very important families today with us. We have the family of Chief Justice Benedicto Kiwanuka. I request them to stand up for recognition. Thank you so much for coming. You're most welcome. We also have the family of Principal Judge Emeritus, the late Justice Tabugova, led by Mrs. Chemima Tabugova. You are very, very, very most welcome. Our chief guest, we have the registrars and the magistrates of the judiciary. Your worships, I request all of you to stand for recognition. I think the screen can be projected to them since they're at the back. There they are. Thank you so much for coming. We have the senior administrators. I request you to also stand for recognition. And lastly, thank you so much. Those are some of the administrators. And lastly, members of the bar who have joined us, I request you to stand. All the distinguished members of the bar, please stand up as we welcome the president of the Law Society to make his remarks.
the chief guest, Right Honorable Ruhakana Rugunda, a special envoy of His Excellency the President, my Lord, the Honorable the Chief Justice, my Lord, the Honorable the Deputy Chief Justice, my Lord, the Honorable the Principal Judge. I'll adopt the protocol laid down by the Chief Registrar for purposes of saving time. Our chief guest, my Lord, the Honorable Chief Justice, allow me first, on behalf of the members of the Uganda Law Society, take this opportunity to ask you to extend our belated happy 79th birthday to His Excellency the President. May the good Lord continue to bless him abundantly. Our chief guest, today we gather again to commemorate the life and enduring legacy of a true inspiration in the realm of justice and human rights. The Honorable Chief Justice Benedicto Kiwanuka is remembered as a man of unwavering principles, a beacon of hope, and an embodiment of selfless dedication to justice, human rights, and the rule of law. We are reminded that he placed the welfare of his country and its people above everything else, and that the judiciary and the legal fraternity are not just institutions, but guardians of democracy and the rights of citizens. Today's theme is focused on enhancing judicial accountability, transparency, and the rule of law. The theme today challenges us to reflect on where we are and evaluate our role in enhancing judicial accountability, transparency, and the rule of law. It is therefore worthwhile, before I go on to share a few reflections and thoughts from the bar on just the way we view it in order to contextualize today's discussion. We know that the transformation agenda of the judiciary was triggered through the enactment of the Administration of the Judiciary Act 2020, which strengthened the independence of the judiciary and streamlined the management of finances in the judiciary, among other key features. This agenda is guided by the Strategic Plan 2020 to 2025, which focuses on recruitment and deployment of more judicial and non-judicial officers and providing them with adequate tools of work. It also focuses on establishing more courts across the country in order to eliminate case backlog and to bring justices nearest to the people. It also focuses on strengthening the Judicial Training Institute to offer up-to-date capacity building and refresher training to the judicial and non-judicial staff. And also, more importantly, the Inspectorate of Courts to effectively supervise court operations, promote judicial accountability, and fight corruption, and also promote innovations to simplify court processes. The implementation of the Judiciary Transformation Agenda has indeed seen more judicial officers appointed, more courts opened, and this has partly resulted in an increase in case disposal. At this point, I would like to thank the judiciary leadership, the government of Uganda, in ensuring that the judiciary gets the much needed resources and also more judicial officers to enhance the efficiency and effectiveness of justice. As we reflect on the theme today, and as we reflect on who Chief Justice Benedicto Kiwanuka was, we must consider that judicial accountability can be used as a tool for promoting efficiency in courts. In speaking to judicial accountability, we are only raising the old and yet unanswerable question Socrates raised: who will guard the guards themselves? We could consider accountability in terms of levels that relate to the wider range of tasks undertaken by the judiciary. Judicial accountability is a very deep subject, and I don't want to go into the theories and the arguments, but there is content accountability, which refers to written, reasoned judgments. There is process accountability, which refers to methods of selecting cases for hearing and assigning cases to judges. There is also performance accountability, which refers to targets, delivery, and outcomes. The most obvious example is the time in which it takes for matters to be determined in courts. And finally, probity accountability in regard to individual judges, mechanisms which are intended to guard against corruption. The Chief Justice Emeritus of the Republic of South Africa, while addressing the first accountability session by the judiciary to the public of South Africa, had this to say on the importance of judicial accountability. We do so not only in recognition of our unique role as an independent arm of the state, but also because of our conviction that with independence comes accountability. We are not self-employed. Like functionaries in the other arms of the state, we are employed by the people, and as their messengers, we owe them an account of what we have exercised, the mandate they charged us with, and the resources they availed us. While we appreciate that the judiciary has largely focused on institutional accountability, as the bar, we believe that it is time to pay attention to content accountability. And that means referring to the quality of decisions which are coming from the courts to ensure consistency in the interpretation of the law. It is also time, and I know that the judiciary has discussed this, to have a performance appraisal system. I know that the discussions have been held on performance appraisal system. As the bar, we are asking that there should be a performance appraisal system to enable judicial officers to also to be held to account. I am cognizant of the fact that as the bar, we also must ensure that we are prepared to go to court and should not be reasons for the delay of justice. So there is a corresponding obligation on the bar. Our chief guest, transparency is one of the themes of today's discussion, and it is one of the fundamental elements of the judicial process. It is also important because it promotes accountability and helps to eliminate arbitrariness. In terms of promoting transparency, I want to applaud the judiciary for taking several measures to ensure easy access to court premises and to information. It has also established a press office, and I think the public relations officer, the new public relations officer was introduced to facilitate media coverage and sharing of information between the judiciary and the public. It has established court users committees and also published annual reports of its activities. These are very fundamental in terms of ensuring that justice is not only done, but said to be done. They have also shared statistical information on the performance of the courts, which is available on the judiciary website as a way of promoting transparency. Our chief guest, allow us to upload the judiciary for these fundamental initiatives that have been taken. As we see it, my Lord Chief Justice and our chief guest, we think that one of the critical processes for ensuring and promoting transparency is the issue of appointment of judges. In order to ensure transparency and accountability in the process, the appointment and selection criteria should be made accessible to the general public, including the qualities required from candidates for higher office. The criteria for appointment, shortlisting, selection, and decision-making process should be predetermined and publicly available. We believe that as a bar, in order for you to fulfill the transformation agenda, it is important for us to streamline the process of appointing judicial officers to ensure that it is based on merit and that it is transparent and that stakeholder comments as much as possible are also encouraged and including comments from the bar, the academia, the judiciary, and the civil society. My lords, if we do not have a transparent process, we may continue to appoint acting judges and acting magistrates and end up with an acting judiciary, because sooner or later, every judicial officer will be acting, and perhaps end up with acting judgments. We must reflect on the issue of acting and appointing people in acting positions, especially for the judiciary. Secondly, on transparency, our chief guest, I believe that it is high time that the judgments of the Supreme Court and appellate courts are translated in at least 5 local languages to ensure that our people understand the judicial decisions emanating from the courts and that we are not leaving anyone behind. Let's look at examples from Tanzania and Rwanda, where judgments, I think in Tanzania, they're in Kiswahili and Rwanda in the local language. If we are providing translation and interpreters in our courts, why shouldn't we be translating our judgments and perhaps providing summarized translations for the benefit of our people? On the rule of law, our chief guests and my lords, the major threat to rule of law currently, especially for the judiciary, is non-respect of court orders. Effective and efficient enforcement of judgments is critical to maintaining public confidence in the courts. We have cases, our chief guest, where, for instance, the resident district commissioners are now calling parties and constituting themselves into appellant courts to reappraise the evidence. Our view is that court orders must be respected and stakeholders must ensure the respect of these court orders. As I close, let us remember that the legacy of Honorable Chief Justice Benedicto Kiwanuka is not just a static moment, but a living and breathing testament to the enduring power of justice and humanity. As we move forward, let us honor his memory by ensuring that our judiciary and the entire legal profession remains a great force of fairness, accountability, and transparency. I thank you for the opportunity to share our thoughts as Uganda Law Society for God and my country.
Thank you so much, President Law Society. Let's clap for him just once again. Thank you for those thoughts. Acting judgments are not our portion as a judiciary. May the Lord help us. We are moving well and we'll be going to our next remarks. Our chief guest and my lord, the Chief Justice. Before we do that, allow me to make another set of recognitions. I recognize the presence of Ms. Nora Matovu, a member of the Judicial Service Commission. You're most welcome. Thank you so much for coming. Together with Mr. Samuel Subuga, a member of the Judiciary Council. Thank you so much for coming. Our chief guest, we have a Judiciary Council that was birthed under the administration of the Judiciary Act of 2020. And so it's a pioneer council in the judiciary. From UN Women, we have Miss Adekemi, the deputy representative. You're most welcome. We have the chairperson of the Insurance Appeals Tribunal, that is Miss Rita Namachika. That is again my classmate. I like to brag about them. There are quite many here. Thank you so much for coming. The Deputy Director of LDC is here, Miss Lydia Namuli. You're most welcome. Thank you so much for coming. The Executive Director of NIRA is with us, Miss Rosemary Chisembo. Thank you so much for coming. And lastly, from Governance and Security, we have Mr. Musa Modoi. We are pleased to have the Honorable Deputy Attorney General, who is going to deliver the remarks of the Honorable Minister of Justice and Constitutional Affairs. I welcome you to make your remarks. Thank you so much for coming.
the Right Honorable Prime Minister, a representative of the President, the Chief Justice, the Deputy Chief Justice, the Attorney General, the Principal Judge, Justices and Judges of the Courts of Judicature, the retired Justices and Judges, Excellencies, Ambassadors and Heads of Missions, the Honorable Members of Parliament, Your Grace, the Archbishop. I'm paying the price for coming late. The DPP, the IGG, Heads of Commissions, the Land Chief Registrar, the Permanent Secretary, Secretary to the Judiciary, our development partners, Your Worships, the registrars and magistrates present, the President of Uganda Law Society and Head of the Bar, the family of the late Chief Justice Benedicto Kiwanuka, members of the media, distinguished guests, ladies and gentlemen. I'm privileged to stand before you to make remarks on the 6th Benedicto Kiwanuka Memorial Lecture. Perhaps I might repeat what you all know, that Benedicto Kiwanuka was the first Prime Minister of Uganda, a leader of the Democratic Party, and one of the distinguished persons that led this country along the transitional path from colonial rule to independence. He later became the first Black Chief Justice of this country. By many standards, even today, he was a prominent man. A man of high profile who, again, by our standards, should have lived a longer life and gotten a magnificent burial. His story, however, did not end in that manner. He was abducted from his sacred chambers at the very high court, at this very high court, by men believed to be of the government State Research Bureau, who murdered him for his unwavering and stand on the rule of law. It is therefore truly befitting that this year's theme for the memorial lecture is enhancing accountability, transparency, and the rule of law. As a citizen of Uganda, and as a court user, and as Minister of Justice and Constitutional Affairs, there is no better message I would want to hear concerning the administration of justice than the one for accountability and transparency. I actually came to purposely hear how the judiciary is doing, it. There's a lot of sweet messages everywhere within and outside Uganda talking about transformation, agenda, equities, plea bargaining, small claims, mediation, and so forth. This annual lecture is important to us as a reminder to reflect on what Honorable Benedicto Kiwanuka, our late Chief Justice, lived for. It is also important for us to examine how we can live up to his legacy and affirm the role of the judiciary as an independent arbiter, effectively executing its mandate as stipulated in Article 126 of the Constitution. Right Honorable, upon deeper reflection, I come to conclude that the judiciary and other members of the legal fraternity have played a big role in enhancing judicial accountability, transparency, and the rule of law in this country. It is therefore important to note that every person has the responsibility to contribute to these ideas. As citizens of this Pearl of Africa, let us individually examine ourselves. Do I honor our Constitution? Do we honor our Constitution and the laws of the land? Do we corrupt judicial officers in their decision-making process? Do we offer solutions to the bottlenecks to the justice service delivery? Or am I part of the hindrances? Each one of us should extend possible relentlessly. Each one of us should, to the extent possible, relentlessly respect and observe the laws of our land and frown upon those that do not, instead of cheering them. It should not become popular to be unruly. Obeying the laws of this country is a principal way of enabling those entrusted with protecting our Constitution to do their job as they should. We just heard the previous speaker talking about violating court orders. So we are all bound to obey the rules of the land. Benedicto Kiwanuka strived to follow the laws throughout his career. He endeavored to breathe life into the laws as Chief Justice. Woe unto those who failed him, and woe unto those of us that worked to frustrate, defeat, and undermine justice. I'm therefore delighted that the judiciary has, over the past couple of years, continuously engaged in reforms with the aim of making justice easy and accessible, both geographically and substantively. Whereas it is important to place a courthouse and a magistrate in every county, it is equally important to let court users have a meaningful experience of court once they get to court. For instance, to be delivered efficiently and effectively, and for us all to continuously advocate for the work towards observance of the rule of law, a close and affable working relationship between the bar and the bench on the one hand, and between the judiciary and other arms and organs of government on the other hand, must exist. Such a relationship cannot exist when we, the members of the bar, the citizens and the court users, development partners, among others, have inadequate information about court processes and judiciary innovations. Not being forthcoming with relevant information would mean that the judiciary is not transparent. Indeed, a lack of transparency results in distrust and a deep sense of insecurity. I want to conclude, Right Honorable Prime Minister, rejuvenated by the memory of the Chief Justice Benedicto Kiwanuka, I renewed my commitment and firmly state that the Minister of Justice and Constitutional Affairs, as Minister of Justice and Constitutional Affairs, I am committed to working with the judiciary to serve the people of Uganda, promote the rule of law, judicial accountability, and transparency for a better Uganda. Thank you very much.
Thank you so much, Honorable Deputy Attorney General, for those very good remarks. Let us give him another round of applause. Thank you, and thank you so much. Our chief guest and my lord, the Chief Justice, we are now proceeding to the highlights of this function where we are going to receive the keynote address. And to introduce the keynote speaker is the Honorable the Deputy Chief Justice, whom I humbly invite to come and introduce our keynote speaker. You're welcome, my lord.
My Lord Chief Justice, Right Honorable Dr. Kiwanuka, representing His Excellency, protocol as laid down by the Chief Registrar. Retired Jotham Tumwesige was a judge of the Supreme Court of Uganda. He started working for government as a state attorney in the Ministry of Justice until 1981. Between 1981 and 1986, he lectured at the Kenya Institute of Administration, now the Kenya School of Government. In 1985, he was a member of the Constituent Assembly that enacted the 1995 Uganda Constitution. He later served as the Inspector General of Government of Uganda. And in 2009, he was appointed a judge of the Supreme Court of Uganda. And he retired in 2019. My Lord, Justice Jotham Tumwesige, you are welcome to address us.
My Lord, the Chief Justice, the representative of His Excellency the President, Honorable Dr. Kiwanuka, the Deputy Chief Justice, the Principal Judge, retired Chief Justices, whom I'm happy to see here. I will stop here and adopt the protocol as given by the Chief Registrar. My Lord Chief Justice, I'm profoundly honored and privileged by your invitation to present a keynote speech at the 6th Benedicto Kiwanuka Memorial on the theme, Benedicto Kiwanuka, Enhancing Judicial Accountability, Transparency, and the Rule of Law, which calls upon the judiciary to reflect on the rule of law and how accountable it has been to the people of Uganda. Benedicto Kiwanuka, in whose honor we are holding this memorial, was, as was said earlier, kidnapped from the chambers here, when he was Chief Justice. In broad daylight, without any fear of what the public might think about it. He was killed later, and his body was never recovered. It was a sad day for this country, and we therefore honor his memory for the sake of human rights, justice, and the rule of law. The people of Uganda must ensure that this type of killing does not happen again. And as most of you know, the killing of the Chief Justice done by the regime of Idi Amin did not end there. The violation of human rights continued in this country. I remember during the Obote II regime, a lot of people lost their lives extrajudicially. And in the past, even before Uganda got independence, there was a lot of extrajudicial killings, especially in the earlier days of colonial administration. A lot of innocent lives were lost in Bunyoro at the hands of the colonialists. Civilians were mercilessly killed. They were not participating in the war, but they were just killed because they feared that Kabalega might recruit them, fight them. In Kigezi, where I was born, a lot of people were killed. There was a movement there against colonialism called Nyonyi Ntono. And the people who participated in that movement were killed by colonialists. So the violations of human rights did not start with Idi Amin, no end there. So Ugandans should swear that these violations never happened to our country again. Article 20 of the Constitution provides that fundamental human rights and freedoms of the individual are inherent and not granted by the state. While Article 22 provides that no person shall be deprived of life intentionally, except in execution of a sentence passed in a fair trial by a court of competent jurisdiction in respect of a criminal offense and the laws of Uganda, and the conviction and sentence have been confirmed by the highest appellate court, which is the Supreme Court. The rule of law, which is enshrined in Uganda's constitution, demands that every person in the land respect the laws, and if he or she breaks them, faces appropriate punishment. The rule of law does not discriminate between the rich and the poor, the high in society and the low. It protects citizens from arbitrary rule, ensures an accountable government, and promotes order in society. The absence of the rule of law can lead to chaos and oppression, and the poor and marginalized groups in society will be the ones to suffer most. Although the Universal Declaration of Human Rights proclaims equality of all before the law, the world is short of effective, transparent, and accountable judiciaries that answer to this dream. The justice system remains elusive, especially to the vulnerable and the marginalized persons due to poverty, institutional limitations, and other challenges. The justice system has the highest level of inequality, with the rich using the fast track system as the poor ride on the slowest track, littered with delays and corruption. It should therefore not surprise us that public confidence in most judiciaries remains far below acceptable standards. The national governments need to invest in the judiciaries to deliver justice as a public good. Investing in the judiciary should be treated as a national priority, given the important role the judiciary plays in society, as this paper will show below. Judiciary is and has always been a critical institution in the governance of any nation. Long before the British came to Uganda, we had our own traditional systems like the Abaramuzi in Uganda, or councils of elders sitting as courts to settle disputes. For Christians in the Bible, the story of how Jesus was tried, brought before Pontius Pilate, convicted, and sentenced to be hanged on the cross is well known. Whereas we may disagree with the way he was tried, at least there was some kind of judicial system, crude as it may appear today. Clearly, in all times, judiciary was an organ of governance that was essential for social cohesion and stability. The Constitution of Uganda establishes the judiciary and vests it with the power to adjudicate civil, criminal, and constitutional cases. By settling disputes, judiciary provides for national stability and economic growth. A vibrant legal and judicial regime can attract investment to the country. Can I have something to drink? In order for judiciary to play its role effectively, it must be independent. This is emphasized by Article 128(1) of the Constitution, which provides that in the exercise of judicial power, the courts shall be independent and shall not be subject to the control or direction of any person or authority. And Article 128 further provides that no person or authority shall interfere with the courts or judicial officers in the exercise of their judicial functions. Independence of the judiciary is a broader concept which covers both institutional independence and individual independence of judicial officers, which is necessary to enable judiciary to administer justice without interference from any quarter. In the South African case, the Constitutional Court laid down the parameters of judicial independence thus. Judicial independence is indispensable for the discharge of the judicial function in a constitutional democracy based on the rule of law. The judiciary should enforce the law impartially, and it should function independently of the legislature and the executive. However, the court went on to emphasize that judicial independence is not an end in itself, but a means to an end. It is the kernel of the rule of law, giving the citizenry confidence that the laws will be fairly and equally applied. An independent judiciary is one which is assured of adequate resources. I may repeat this, an independent judiciary is one which is assured of adequate resources in order for it to do its work. At an individual level, judicial officers must enjoy the independence to make decisions based on the law and facts before them, without interference from or fear of any person or authority. Judiciary must not only be independent, but it must be seen to be independent. And judicial officers must avoid creating perceptions in people's minds that they are not independent. The Uganda Code of Judicial Conduct emphasizes this principle by stating, and I quote, "A judicial officer shall exercise the judicial function independently on the basis of his or her assessment of facts and in accordance with conscientious understanding of the law, free of any direct or indirect extraneous influences, inducements, pressure, threats, or interference from any quarter for any reason." Decisions which courts make are bound to please those who are successful and to displease those who are not successful. This is to be expected because by nature of our judicial system, in litigation, there will be winners and losers. What is unfortunate, however, is that in our society today, a party who loses goes out claiming publicly that he lost because his opponent bribed the judge. This creates a bad image of the judiciary. I remember when I was still serving in the Supreme Court, we had a case where concerning property and mortgage, where one of the parties who lost the case stated in the media that each one of us had been given 500 million shillings. My former colleagues, Chief Justice Emeritus, and some others may have been part of that panel, and were astounded to read that kind of thing in the newspapers, that each one of us got 500 million shillings. We summoned that person, and he appeared before us, and we asked him to show cause why he should not be punished for making that defamatory statement. And he apologized to us and issued a statement withdrawing the earlier statement, alleging that we had received bribes of 500 million shillings. So this kind of thing tarnishes the image of the judiciary, and the bad image sometimes the judiciary attracts is not necessarily because it is completely infested with corrupt judicial officers, but it is because of these people who spread false rumors that they lost their cases because the judges and judicial officers were bribed. The Uganda Code of Judicial Conduct emphasizes impartiality as an important principle to be observed by every judicial officer. The code provides that impartiality is the essence of the judicial function and applies not only in the making of a decision, but also the process by which the decision is made. Justice must not only be done, but must also be seen to be done. Accountability. The judiciary is a public institution that is maintained at the public expense and exercises judicial power on behalf of the people. Article 126, Clause 1 states, judicial power is derived from the people and shall be exercised by the courts established under this Constitution in the name of the people and in conformity with the law and with the values, norms, and aspirations of the people. The import of this provision is that the ultimate judicial authority lies with the people, and that the judiciary is accountable to the people of Uganda and the law. I should hasten to add that an accountable judiciary is one that observes the time-tested principles of integrity, impartiality, propriety, diligence, professionalism, equality, transparency, and competence that are all well expressed in the Uganda Code of Judicial Conduct. It is important for judiciary to manage itself effectively, measure its performance accurately, and account publicly for its performance. Therefore, the judiciary as an institution and judicial officers must be accountable to the people for the resources they enjoy and the power they exercise. As Justice Sandra Day Ockner of Denver stated, judges must be accountable to the public for their constitutional role of applying the law fairly and impartially. True accountability advances judicial independence and the paramount rule of law. Judicial integrity, end of quote. Judicial integrity and judicial competence are the hallmarks of a judiciary committed to upholding the rule of law, and they are the principles for which the judiciary should be held accountable. Guided by the 1995 Constitution, Uganda has provided for an independent, accountable, and transparent judiciary and set minimum standards for the courts to observe in the administration of justice. Article 127 of the Constitution provides that Parliament shall make laws providing for public participation in administration of justice, again underscoring the importance of judiciary as a people's arbiter in the appointment of judicial officers, which the President of the Law Society referred to a few minutes ago. The Constitution provides that Judicial Service Commission shall be composed of commissioners, including 2 commissioners representing the public. And this again underscores the importance of the people's involvement in the administration of justice. Observance of the above fundamental principles of justice ensures that the justice system is not only capable of providing justice as a public good, but does so in a manner that caters for all segments of society, especially the vulnerable and the poor, who are either excluded or feel discriminated against according to the society's settings and practices. Uganda's response to the challenges. Case backlog. Case backlog is a perennial problem for the judiciary, but you may take consolation or comfort in the fact that I have been reading about other judiciaries, and actually they all suffer from the same problem of case backlog. But this is not the right thing. I mean, I'm not saying it should continue, but it is a universal problem. Still, efforts should be made to reduce it. I'm aware that this problem in Uganda is caused by a number of factors. Some of them are inadequate number of judicial officers, lack of sufficient funds, insufficient laxity of some judicial officers to handle cases in a reasonable time. And some of these challenges can be overcome with sufficient funding and close supervision. The executive should be applauded for enabling recruitment of more judges and other judicial officers in recent months. It should really be applauded, and I would like to ask you to clap for it. And I hope that more judicial officers will be appointed in future, because they are not yet enough. Uganda designed a comprehensive case backlog reduction strategy whose overall objective is to eliminate case backlog. The strategy was informed by a nationwide case census, which established the number of cases and the extent of the case backlog in the system. Though the dividends of the strategy are yet to be fully realized, it is encouraging that case backlog has some extent gone down. So I thank you, the judiciary, for this effort to reduce the case backlog. I'm reliably informed that some judicial officers with delayed and pending judgments have been asked to take leave to write their judgments. This is intended to eliminate delayed judgments, which have been a source of distress and sometimes concern to the public, who imagine that the court is delaying judgment with the hope of getting a bribe. Again, what I mentioned earlier. I think disciplinary proceedings in the judiciary need to be strengthened, because simply sending a judge on leave to complete his judgments is not enough. I think we should have a mechanism whereby judges and judicial officers who cannot write their judgments are given more stricter punishments than simply sending them on leave. Enhanced public involvement. Judiciary has adopted a systematic way of engaging stakeholders on a monthly and biannual basis. At a monthly level, all the justice service actors at district level meet with civic and local leadership, discuss ways of removing impediments to the administration of justice. Civic leaders raise the concerns of litigants, which are also addressed at the meetings. At the biannual level, every court hosts an open day at which the court explains its services and opens up to public scrutiny. Engagement with other arms of the state. Improved relations and mutual respect between the executive, legislature, and judiciary is essential for the proper functioning of the judiciary. The judiciary relies on the legislature for making appropriate laws and for appropriating resources to the judiciary. So it is very important that relations between the executive and the judiciary and the legislature is harmonized so that the three arms of state can work together for the good of this country. On the other hand, the judiciary needs the executive because it is responsible for laying policy, initiating laws, and making proposals on the budget. Addressing gender-based discrimination. Addressing gender-based discrimination in the justice system is key to engendering the administration of justice and therefore making the administration of justice inclusive. Increasing judicial remedies that favor the disadvantaged. Increasing procedures and remedies that are affordable, less formal, and easy to use by court users is a game changer for the poor and other vulnerable persons. In recognition of the special challenge that the poor face in accessing court services and the need to expedite justice, the judiciary introduced and implements the small claims procedure, plea bargaining, and mediation as alternative dispute resolution mechanism. May I take this opportunity to thank the Principal Judge Emeritus for initiating some of these mechanisms, like small claims, procedures, plea bargaining, and mediation. I hope these mechanisms are still continuing and getting more strengthened. Specialized courts. Specialized courts have proved to be very effective in addressing vital areas of the economy and public demand for customized court services. The commercial court has helped to deal with the increasing demand of settling commercial disputes as a way of attracting and retaining investors and supporting the rapid transformation and expansion of the economy. The Anti-Corruption Division of the High Court has done wonders, actually, and I should take this opportunity to salute it for the good work they are doing. Section Annual Performance Reports. Section 39 of the Administration of the Judiciary Act obliges the judiciary to publish every financial year an annual performance report detailing the achievements and shortcomings encountered during the financial year. Through this medium, the judiciary accounts the people of Uganda for the financial and other resources received and makes an undertaking to improve service delivery in the coming year. What else should be done? A, the silver bullet for making the judiciary inclusive lies in dealing with the inequalities that are now becoming more pronounced in the justice system. The physical barriers that must be overcome include long delays, prohibitive costs, absence of legal aid, absence of remedies that are preventative, gender biases, lack of adequate information, a formalistic and expensive legal system, poverty, and ignorance, among others. Judiciary should focus on immediate underlying causes that impede access to justice. These include lack of safeguards to access justice, insufficient mechanisms to uphold justice for all, and failure to identify claim holders. This must be followed by an analysis of the capacity gaps of claim holders and duty holders to help them meet their responsibilities and obligations. Eliminate corruption in the administration of justice. Corruption undermines the reliability of the judicial system, generally reinforces the discrimination, and disadvantages the poor and the vulnerable groups. According to Transparency International, judicial corruption is a threat to the independence and impartiality of the judiciary. Judicial corruption is equally a major drawback to having an effective, accountable, and inclusive justice. Improve customer care at the courts. Effective customer care for litigants at the courts is critical to improving the efficiency, effectiveness, inclusiveness of courts, and public trust, particularly for many litigants who find it difficult to use the court system. Customer care can be used to widen and deepen access to justice by employing cost-friendly strategies that have proved instrumental in many jurisdictions. Such interventions include locating the courts at appropriate area, in appropriate areas, listing courts in telephone directories, regularly posting court information on institutional websites, use of mobile courts, video conferencing, concierge services, clean and safe courthouses, and providing an adequate and suitable space for court users, among others. In addition, judicial officers should be visible and get involved in their communities outside courtroom by participating in community meetings and explaining how the court works. Enhance the use of ICT in administration of justice. The World Development Report of 2016 observes that digital technologies have boosted growth, expanded opportunities, and service delivery across the world. According to the World Bank President Jim Yong Kim, among the poorest 20% of the households, nearly 7 out of 10 have a mobile phone. The poorest households are more likely to have access to mobile phones than toilets or clean water. This is what the president of the World Bank said. We must take advantage of this rapid technological change to make the world more prosperous and inclusive. Judiciary can therefore take advantage of the digital revolution and its dividends, among others, to increase access to justice by linking up the litigants with courts, providing information to litigants using electronic and social media platforms such as WhatsApp, developing and launching case managed systems, streamline processing of cases, digital presentation of evidence, providing a platform for complaints, handling and customer care management, and facilitating sharing of information among judicial officers. The Uganda judiciary started the process of enrolling courts onto the Electronic Court Case Management Information System, HMIS, database to improve case management, eliminate corruption, and offer time-bound justice at a lesser cost. In this regard, I think Justice Chiriabwire was very, very active in the creation of HMIS, and I'd like to thank him very much. HMIS has helped litigants to access court services in the comfort of their homes and offices. Cases are filed electronically and feedback is given on the same day. Assessment and payment of court fees is equally done electronically, as well as exchange of documents between litigants and the courts. The parties are only required to physically attend before court only at the time of giving evidence. Once HMIS is rolled out across the courts, the cost of accessing justice will greatly reduce. Invest more in the judiciary. The judiciary is not adequately funded, though I have heard that there has been a reasonable increase in the budget of the judiciary, for which the executive should be thanked. But like Tom Sawyer said in the past, judiciary wants more, because the money that they are getting, which I think accounts for something like it's now 381 billion, is not enough, considering all the courts in the country that have to be facilitated. I'm aware that in the countryside, grade 1 magistrates don't have courts. They don't have courts. And some of the courts which are hired near bars, where there is so much noise, you can't hear what is going on. I visited some, when I was in judiciary, I visited some of the courts, placed close to the bars. And I asked the magistrate who was in charge of that court how he managed to hear evidence being given in court. He says, we do it with a lot of difficulty. And the government committed itself to ensuring that a grade one magistrate is established in every district, and ideally in every sub-county. But some sub-counties and districts don't have grade 1 magistrates. So it is very, very important that resources are available to the judiciary to enable it to make the judiciary more effective in its functions. The government, I think I've mentioned this, I will come now to the conclusion. Building transparent and accountable judiciaries is within our reach if we can build a court system that is capable of meeting the needs of the people. The judiciaries cannot therefore remain inward-looking. Judiciaries have to change and embrace people-centric policies if they must remain relevant. The transformation of the judiciary, however, calls for total personal commitment on the part of judicial officers to adopt modern case management strategies which are anchored on improving the quality of judicial outcomes at least cost and within the shortest time possible. The judiciaries, on their part, must not relent in simplifying, customizing, and integrating justice services to increase access, maximize customer experience and satisfaction necessary for increasing public confidence in the administration of justice. Governments must do more than pay lip service to strengthen the judiciary by allocating adequate funds to provide services, develop appropriate infrastructure and ICT, put in place appropriate laws, develop legal aid schemes, and generally provide a conducive environment for the courts to function effectively. After all, courts are part of the human heritage and must therefore be preserved for posterity. This is what I believe Chief Justice Benedicto Kiwanuka would have done if he had lived to complete his term or to retire before he met his untimely and cruel death at the hands of a ruthless regime of Idi Amin. I thank you all for your patient listening.
Thank you so much, my Lord. We all agree he has done justice to that paper. A very, very wonderful keynote address. Let us give a very befitting round of applause. My Lord, thank you, and thank you so much for those reflections and that message. I believe it leaves us in introspection, all of us seeing that we can do what would make Chief Justice Benedicto Kiwanuka very, very happy. As we reflect on this message, we are going to take 2 minutes listening to Prison's Band, just so that the message can sink, think about it, reflect upon it, and then thereafter we will proceed with the citation by the Honorable, the Principal Judge. Prison's Band. Thank you very much, Prisons Band. I now request all of us to settle down once again. And Prisons Band, maybe just finalize the chorus so that a few people who had stepped out can come back. I see some on their way, just half a minute. Thank you, Prisons Band. Thank you so much. My Lord, the Honorable, the Principal Judge, I invite you.
The Honorable, the Prime Minister, representing His Excellency the President, my Lord, the Honorable, the Chief Justice, my Lord, the Deputy Chief Justice, let me adopt the protocol earlier on outlined by the Chief Registrar. My role here is to give a citation of the awardee of today, and that is the Honorable Mr. Justice Jeremiah Herbert Ntaboba, PJ Emeritus. Honorable Justice Herbert Ntaboba was Uganda's first and longest serving principal judge, having served for a span of more than 15 years, and he left office in 2004. He is much remembered for his decision in the Environmental Action Network Limited versus Attorney General and National Environmental Management Authority, that is High Court Miscellaneous Application number 39 of 2001, where he disregarded the norm that representative actions in public interest litigation must only commence with the written consent of all the beneficiaries, and that the beneficiaries and the public interest representatives should have the same interest in the subject of litigation. The Land Principal Judge delivered his decision on the 28th of August 2001, holding inter alia that, and I quote, "My understanding is that the interest of public rights and freedoms transcend technicalities, especially as the rules of procedure leading to the protection of such rights and freedoms. The applicants say they are especially interested in the infringement of the rights and freedoms of the poor and children, those who cannot know and appreciate their rights and freedoms, and who do not know where to go and how to go there for redress. Is it not compelling that a body like the applicant stands up for them and fights for their cause, I think the application deserves hearing, and I will hear it. End of quotes. The Honorable Ntabuoba is therefore hailed for opening the doors to public interest litigation in Uganda, which enhanced access to justice for all and sundry, especially the common poor and the defenseless. Justice Ntabuoba stood for his straightforwardness. He was a judicial icon who lived for the words of the judicial oath. He juggled administrative work and hearing of cases. This made him a very influential judicial officer who closely supervised colleagues in the execution of their work. He made every judge under his supervision accountable for his or her actions. His work ethic and timekeeping were incredible, and he expected other judicial officers to tag along without any excuses. Besides his impeccable work ethic, he came to personify candor in the judiciary. He was always principled and charismatic, and administered the High Court like the Colossus. He was forthright both during court sessions and even out of court in his daily life. He was born in Kisoro on July 21st, 1939, to Zakayo Bakunzi Rujiriki and Maria Bakunzi Nyirajana. He graduated with a Bachelor of Laws degree from the University of Dar es Salaam in Tanzania in 1966. His formative employment years saw him serve in several important government positions between 1973 and 1981. He served as the Registrar General, Administrator General, and Official Receiver of Government. In 1976, he was awarded the Distinguished Service Medal by the government of Uganda, and in the same year, he was also certified in intellectual property from Australia. He went into exile in 1981 during the political insurgency in Uganda. Between 1981 to 1987, he served as the first Director General of the African Regional Industrial Property Organization, in brief, ARIPO, based in Harare, Zimbabwe. When he was the Director General of African Regional Industrial Property Organization, ARIPO, based in Zimbabwe, he drove around in his Mercedes saloon from Harare through Zimbabwe, Tanzania, Burundi, Rwanda to reach his home in Kisoro through Chanika border post, all for the love of adventure, depicting a fearless man as Ntabuoba was. Actually, the name Ntabuoba means fearless. The name Ntabuoba means fearless one, which the principal judge emeritus exhibited wherever he worked. He was a tough man who never compromised anything whenever he was required to defend the integrity of the independence of the judiciary. And I tested his toughness one time when I appeared before him as a young lawyer with I had gone with my senior, my boss, and I knew I was standing behind a lion. So when we went to him, we had a matter involving a patent, a trademark actually. He sent us back to school. We actually ended up withdrawing the matter, and you can imagine when you are standing behind the shoulders of a lion and you are a squirrel, and then the lion withdraws the case. He served as Chancellor of Uganda Pentecostal University and Chairman of ARIPO Appeals Tribunal, which is sort of disputes arising from the grant of patents and other aspects of intellectual property matters. While he was still the principal judge, he was appointed a visiting professor at Georgetown University in USA. After his retirement in 2004, Justice Ntabuoba served as a legal consultant on intellectual property at Kampala Associated Advocates, one of the leading law firms in Kampala. He passed away on the 12th of April, 2020. This is therefore a posthumous award to be received by his family. Rest ye in peace, the fearless one, for God and my country. Your Excellency, that is the awardee we have today. Thank you.
Thank you very much, my lord, the Honorable Principal Judge. Let us thank him for the citation. We now proceed to the presentation of the Chief Justice Benedicto Kiwanuka Award for the year 2023. And this is going to be done by our chief guest, who will do it together with the Honorable, the Chief Justice. I humbly therefore invite you to the front. I'm sorry, we are not going to do it up here. We'll do it down to allow Mrs. Janina Tabgoba to receive the award. So I request Mrs. Janina and family to accompany her to receive the award from in front here. Cameras, let that be your point of attention at this point. My Lord CJ, you can read the award. Thank you.
It's my pleasure to give you this award on behalf of a distinguished husband who performed important and principled work for the judiciary and for the country, and set a very good example for both the young and the old. Congratulations.
Thank you, Mama.
Can we have a photo moment for the family at that point? Thank you so much for the photo moment for the family. Mama, I would request you to remain right there with family. Our chief guest and the Honorable Chief Justice, I would request you humbly to resume your seats. And then we'll proceed to hear remarks from the family.
All right, Honorable Wakanarugunda, representing the President of Uganda. Chief Justice, all protocol observed as guided by the Chief Registrar. Good afternoon, ladies and gentlemen. It's my pleasure to be greeting you after losing the icon of a man whom we are celebrating receiving the award today. I haven't seen many of you. It is a great honor, indeed, to receive this prestigious gift award. On behalf of my family, Jeremiah Tabova for his unwavering commitment to the judiciary in Uganda. As many of you are aware, as has already been mentioned, Justice Tabova was uncompromising in his pursuit of the law, a motivation which he upheld in both professional and personal life. He fully understood the need to ensure the independence and integrity of judiciary with the motivation to ensure justice for every Ugandan. Standing here today at the High Court is particularly nostalgic for me, as I recall, and the children also, as we recall, how he spent many hours in these judicial chambers, working passionately and diligently to serve his country in the best way he knew how. I take this opportunity to most heartily thank the judiciary and His Excellency President Yoweri Museveni for all the help offered to us when we lost our beloved patriarch in April 2020 during the first COVID pandemic lockdown. What was a difficult time. It was made even harder because of the unfortunate situation we found ourselves in as a country where no one was able to move about, let alone interact freely. But some of you braved it and came to see us. We thank you so much. We won't forget the contributions and the words of kindness. Without your support and assistance, we would have felt completely isolated and overwhelmed as a family. We were so humbled and will forever be grateful for the immense support we received from the judiciary fraternity and the government of Uganda as such a trying time. At such a trying time. Justice Tabova was a loving husband and a father, and he imparted those same principles of integrity and an unwavering commitment to us at home. These are traits that each of us strive to emulate even today. We as a family are proud of this contribution and in his great legacy. We thank the judiciary for recognizing him in such a befitting manner. Actually, the name Tabova, the true meaning Tabova, because he was with God. When you are with God, everything is possible. You can do your work. That's how he managed to do his work at peace, because he was not fearing. He knew God knew everything. May his soul continue to rest in peace. And
thank you so much, Mama Penina and family. Let us thank them. Sorry, Mama Jenina and family. Thank you. Thank you so much. Lessons to take home. There are many today, even from the life of the late. Once the family settles, we shall proceed to the next part of our program, where we shall be hearing the speech, of the Honorable the Chief Justice, who will in turn invite our chief guest. My Lord Chief Justice, I humbly invite you to come and deliver your speech. You're most welcome.
The Right Honorable Ruakana Rugunda, Special Envoy of the President of the Republic of Uganda, and chief guest today, the Honorable Deputy Chief Justice, the Honorable Chief Justices Benjamin Odoke and Bart Katrebe, the Honorable Deputy Attorney General, the Honorable Principal Judge, the Honorable Justice Jotham Tumesije, our guest speaker today, the Honorable Principal Judge Emeritus Justice Yorokamu Bamwine, Your Excellencies, the heads of diplomatic missions, honorable members of parliament, honorable ministers, honorable members of parliament, representative of the archbishops of Church of Uganda and the Kampala Archdiocese, representative of the Inspector General of Government, the chairpersons of constitutional commissions, the representative of the Director of Public Prosecutions, the Honorable Retired Justices and Judges. I think I skipped, and because I do not want to suffer your wrath, the Honorable Justices and Judges of the Courts of Judicature. The Chief Registrar of our Courts of Judicature, the Secretary to the Judiciary, the worships, registrars and magistrates, the President, Uganda Law Society, and distinguished members of the professional bar, the family of Chief Justice Benedicto Kiwanuka, the family of Honorable Principal Judge Emeritus Herbert Ntabgoba, participants online, distinguished guests, ladies and gentlemen. I warmly welcome each one of you to the 6th commemoration and honoring of the memory of Chief Justice Benedicto Kagimo Mugumba Kiwanuka, who was tragically disappeared on this day by the ignoble regime of Idi Amin 51 years ago. His Excellency, the President of the Republic of Uganda, has not been able to be with us today. This being the first time he has not officiated at the Benedicto Kiwanuka function. In view of the particular importance he has attached to this function previously, as has consistently been exhibited by his unfailing attendance, his failure to attend can only be, for some reasons, be beyond this control. Chief Justice Benedicto Kiwanuka, the first Ugandan national to hold that high office, was last seen alive exactly 51 years ago today. We believe the cause of Chief Justice Kiwanuka's demise was his issuance of a writ of habeas corpus, directing the military authorities of the day to produce a British citizen in court, as was provided for in the law. He was flagrantly and violently abducted from his chambers soon afterwards. He's never been seen since that date. Therefore, Chief Justice Benedicto Kiwanuka was martyred for defending the rule of law and fundamental freedoms of the people of and in Uganda. The theme for our lecture this year is, as has been pointed out, Benedicto Kiwanuka, enhancing judicial accountability, transparency, and the rule of law. As the judiciary service continues to draw inspiration and motivation from the works and services of Benedicto Kiwanuka, we are reminded of our constitutional obligation of accountability to all justice seekers in Uganda in our actions and decisions. Accountability has been expressed to mean, open quote, the acceptance of responsibility for one's own actions, including a willingness to be transparent and allowing others to observe and evaluate one's performance, close quote. This is by Will Kenton. I've given the citation where you can get his works. Judicial officers are not only individually accountable internally to the judiciary service, but we are also externally accountable to the public that we serve. So it's a twin responsibility. We are accountable to ourselves. As a matter of fact, a judicial officer is first and foremost accountable to himself or herself, accountable to your conscience. Then you're accountable to the judiciary of which you represent, and then to the justice seekers and the public at large. Article 126, Clause 1 of the Constitution of Uganda succinctly provides that, open quote, judicial power is derived from the people and shall be exercised by the courts established under this Constitution in the name of the people and in conformity with law and with the values, norms, and aspirations of the people, close quote. Judicial accountability therefore requires that judicial actions, inactions, and decisions be made in the interest of the people that we serve. It also requires that our decisions and undertakings be satisfactorily explained to our people. Finally, judicial accountability is a call to all of us to use judicial power correctly and within the boundaries of the law. Every judicial officer is duty-bound not only to issue correct decisions, but also to explain in clear terms, clear language, the reasons for one's decision and ensure that the same are transparently enforced in accordance with the law. A judicial decision, judgment, or ruling is defined as the reasoned opinion of the judicial officer who is delivering that judgment or ruling. So a judgment cannot be a one-liner. It must be reasoned. One must explain how you arrive at a decision and why you make those conclusions, the orders that you make. Judicial accountability must, however, be considered with strict adherence to the independence of the judiciary. Many times, including those who are in the judiciary, we muddle up the expression independence of the judiciary. The core meaning of independence of the judiciary is that in our judicial function, in the exercise of our judicial function, nobody must determine for you, must direct you, must improperly influence you to make a decision which is your constitutional mandate to make. A judicial officer must stand firm. This does not mean you do not consult on points of law with your colleagues, but ultimately the decision is yours. And that's why you take oath not to be influenced by fear, by favor. You should not be vengeful. You should not deliver decisions out of affection for either or for one of the parties. It must be your decision. It must not be influenced by any extraneous factors. That is the true meaning of independence of the judiciary. And then you go to other factors which affect the independence I've just spoken about. Things like financial independence, not to be beholden to somebody else, because it will weather down your independence and so on and so forth. But the core is that in making your judicial decision, it must be guided by your understanding of the law, your appreciation of the evidence, and what you must fear most is your conscience. Have you done justice in a matter? After delivering your judgment, do you go back home and sleep peacefully? Or are you haunted by the ghost of injustice? That is really, really what independence is about. Now, this independence the judiciary or judicial officers enjoy calls for respect for judicial decisions and support for judicial operations by all arms and agencies of the state. The law is clear on who makes judicial decisions, who enforces judicial decisions. Any establishment any intervention outside of the provision of the law is unlawful and fetters down the independence of the judiciary and is an abuse to the rule of law that we stand for. that it is our responsibility in this country to protect, defend, and stand up for. I have seen agencies of the state committing the sacrilege of purporting to interpret decisions of judicial officers. Refusing to implement decisions of judicial officers, court decisions. This is wrong. This is contrary to the principle of the rule of law. Those charged with the responsibility to implement or enforce judicial decisions may have reason to question those decisions. The proper place is to come back to the court which issued such decisions. If they think they do not understand the meanings, come back to the courts. Satisfy yourself that this is what the decision of the court is. And then either you facilitate or you ensure that the decisions are implemented. It's a mockery of justice to have judicial officers do what is within their powers to come to decisions, and then somebody else, obviously ill-equipped to even make meaning of these decisions, just stamping that we cannot enforce this decision. As I said, this is a sacrilege, an affront to the principle of rule of law. And we must all stand up against Learned Counsel, Attorney General. We must all stand up. You advise government. We must all stand up. Either we accept the courts of law or we close the courts of law and hand over these functions to other persons. We have to make a decision on this. The judiciary transformation agenda that we are now pursuing focuses on enhancing access to justice services across Uganda. We are therefore establishing more courts across the country in order to afford justice seekers in this country meaningful access to justice. For this, my Lord Chief Justices who preceded me, I am favored now to have 81 judges, where you had 40, and at times 30 judges of the High Court. I now have 86 registrars. I think at your time, some of you had 4 or 5. I now have 92 chief magistrates. I think my immediate predecessor would be happy to hear this. During his time, he had about 30-something chief magistrates, and some chief magistrates had to take care, in addition to their station, 3 more magisterial areas. Some of those fellows spent more time on the road reaching those various areas than sitting in court. I now have 371 grade 1 magistrates. We have registered remarkable impact in this regard. I've said this before. In the pursuit of our transformation agenda, we must have a chief magistrate in every local government district. and then a magistrate grade 1 in every county constituency. We are in a massive process of creating more high court circuits so that justice is not only for the rich, but justice is also for the peasant who cannot afford a bicycle to go to court. This is the first step towards affording our people, the justice seekers, access to justice. I always call it the hardware in the judiciary. But the hardware can be everywhere. It can be very beautiful, can be nice looking. But if it takes you 3 minutes to open your laptop or to open your phone, and then another 2 minutes to get to the function you want, then despite the beauty of the hardware, that IT gadget is as good as useless. The most important where in judicial function are the judicial officers. They are the software. However ugly looking the hardware is, or even if there was no hardware, so to speak of, a conscientious judicial officer who renders justice under the tree who is clothed with integrity, who abides by the rules governing the functions of the judicial officer, is the one who is affording justice seekers true access to justice. So when we honor the memory of Benedicto Kiwanuka, we ask ourselves, at the end of the day, would I be remembered by the community which I serve, whether you've been posted to Kabong, Kisoro, Bundibujo, Mubende, Busia, Soroti, would the community remember you for being upright? Would the community remembering you for ensuring that the rule of law prevailed in your respective courts? Or would the community consider your transfer from their place as good riddance? These are questions we need to ask ourselves. We are also promoting innovations to simplify court processes and enhancing the use of ICT in the delivery of justice services in order to demystify court services and make courts more accessible and user-friendly. In the Judiciary Strategic Plan 5, which has been running from the financial year 2020 and will conclude in the financial year 2025, we aim at, among other things, enhancing equitable access to judiciary services and improving coordination, partnerships, and accountability. We've also found it cheaper and expedient to recognize and support alternative justice systems, especially mediation, small claims and plea bargaining. The point which our guest speaker dwelt on today. Backlog in justice delivery is a very painful thing. Painful for the judiciary, painful for court users. Indeed, the reason we've always called out for support by the executive and I personally believe, and indeed, if we put our priorities right, we can do it in this country. And I hasten to add, we can even do it during my tenure in office as Chief Justice. If we put our priorities right, it is possible to have chief magistrates in every district, magistrate grade 1 in every county constituencies. It's possible to have 40 high court circuits with a minimum of 2 judges in each circuit. It's possible to expand the Court of Appeal by operationalizing the 8 circuits we have identified. If that were done, beginning with the magisterial courts, I am clear in my mind that it would be possible to demand of each of these judicial officers to conclude any matter brought before them within 12 months. And if a matter stays with you in excess of 12 months by 1 day, you should be compelled to give a written explanation to the Chief Justice why you were not able to conclude in 12 months. Augmented by the technological innovations I've spoken about, this is possible. And indeed, this would have a direct impact on the economy of this country. I would say the same with judges of the High Court and ultimately the appellate courts. If we put our house in order, if we stop looking at the judiciary as a consuming institution, if we realize the role, the place of the judiciary in enhancing do this today, not tomorrow, not the other day. We can do all this today. So my call is to the executive and to Parliament to reconsider this position. The judiciary is one of the 3 arms. Many times people say it is the 3rd arm, and that's why we are made to suffer like this. The judiciary is not the 3rd arm. It is one of the 3. With equality of force of arms in our function. I have yet to be persuaded that there is any sense in Parliament's budget being 800 billion and that of the judiciary having been condemned to 199, 198 billion has been increased to 300 only. So we must sit down and speak about these things. So that each and all of the organs of state play their meaningful role as mandated by the Constitution or the law. We put in place a process where selected retired judges, two of whom have been recognized here, Principal Judge Emeritus Surkamu Bamine and retired Justice of the Supreme Court, Paulo Mugamba. We had some basic training on alternative dispute resolution. I really want to thank the lordships and other judicial officers who attended this training for the enthusiasm with which they embraced this move. In countries like the United States of America, over 95% of dispute resolution is done outside courts. Over 95%. Mediation, arbitration, conciliation. In the criminal justice sector, it is even more. About 98 or thereabout percent is sorted out, plea bargain and other arrangements. We need to pursue this. We need to pursue these alternative dispute resolution mechanisms. First of all, it is in sync with our African culture. When I've been attending a master's program in alternative dispute resolution, because I intend to spend the remainder of my life after retirement doing alternative dispute resolution with village people, not with these town fellows. Just with regard to urban, I want to be in oblivion. You'll find me where I think life is more meaningful. So I have been protesting in our class where I'm not the Chief Justice, I'm the chief student, and my lord, the Deputy Chief Justice is the Deputy Chief Student. And then we have a handful of other very interesting classmates. So I have been protesting that here we should not be saying African jurisprudence or African mode of justice delivery is alternative justice. It is the original justice. It is the one imposed on us by colonialism, which is the alternative justice mechanism. So I'm going to put up a center in Gulu, and I'll call it ADR, not for alternative, but for African Dispute Resolution Center. But I believe, and we will expand the base of personnel to help the judiciary in dispute resolution. This will have remarkable impact on service delivery, judicial service delivery in this country. In order to further enhance accountability in the judiciary and access to justice, we have revamped the Inspectorate of Courts by increasing the number of inspectors. You remember I told you that we have some 80 or something registrars now. So we are going to increase the number of inspectors and equip them with the necessary tools of work, ready to track down any form of indiscipline in the courts. We also plan to decentralize the inspectorate to regional level to make it more responsive to the concerns of justice seekers. I'll tell you something which happened to me. Where is our new registrar for inspectorate? Pamela Lamon, where yesterday, he's already started, they say the stick and carrot. Yesterday, she mirthfully, you can sit down, Ms. Worship. She mirthfully applied the stick on me. I'd given her an assignment. She wanted to come and discuss with me. So she calls me about 8 something and says, my lord, where are you? I've not seen your team here because your presence is always quite noticeable. I said, I'm finishing. Indeed, I was finishing something. I normally do that. I wake up early and do some writing. So then she tells me this, and you enjoy say, this is the registrar inspectorate speaking to you. I think I told the chief registrar yesterday. I thought that was very good because inspectorate begins from up. Fish, the mafia say, begins rotting from where? Yes. So when the registrar said, this is the registrar inspectorate speaking to you, I got the point. So for us, we intend that every judicial officer, and I really mean every judicial officer, must do their work knowing somebody is breathing on their neck from behind. And we'll set up peer groups. Maybe the inspector may not be strong enough to come to the Chief Justice and say, but Mr. Chief Justice or Mr. Deputy Chief Justice or Principal Judge, this. We will have peer groups where your colleagues will come over to you and instill the fear of the Lord in you without using the stick. With better funding of the judiciary, we can truly honor the memory of Chief Justice Benedicto Kiwanuka better by affording access to justice to all justice seekers in this country. We owe it to Chief Justice Benedicto Kiwanuka to do all that is within our individual and collective power to further advance the cause of justice. I call upon all the people of Uganda, the government and non-governmental agencies to join hands so that together we strive for the rule of law, access to justice, and observance of human rights for all our people. It is incumbent on all of us to search our individual and collective souls and establish whether in the pursuit of the law we are inspired by what it stood for without fear. Let me also say this. In my adult life, when I was in public service, where public means even in private practice, I was serving the public for a fee. And then in service in government, as a member of the executive and as a member of the legislature, and now as a member of the judiciary. This is what I've noticed, and indeed, a day commemorating the life of Benedicto Kiwanuka. It's a proper occasion to say this. In this country, we have spoken peace to people who have been fighting. But for some strange reason, we do not speak peace to people who only shout at us. We do not give audience to ourselves. I remember in 1988, our guest speaker of today and I, on opposite sides of representation, made the document that was signed between the government of Uganda and the northern-based Uganda People's Democratic Movement stroke Army, the one that brought the Walter Ochoras out of the bush. The document was appended on Saturday, 3rd June 1988 in Pese Stadium in Gulu. Then again, it fell on me with other colleagues, including our chief guest today, to talk peace with Joseph Kony of the LRA. We were in the jungles of southern Sudan, a place we've never heard of called Rikwangba, a few meters from the boundary with the DRC. To speak peace with those who had taken up arms. Why do we make it? Why don't we speak peace to ensure that people don't have to take up arms to express their discontent? If Uganda was a country where we speak to one another, informally and formally, if Uganda was a country where people would ask or seek to know, to understand better what they do not, if during the time of Chief Justice Benedicto Kiwanuka, we had the culture where if the executive did not understand a court decision, they knew they had to seek an explanation and it would be given. We would not be here today commemorating Chief Justice Benedicto Kiwanuka. We in the legal profession would know he lives on when we cite his decisions, when we cite the authorities, landmark cases and so on. My appeal as a Ugandan, as a person who owns this country equally with you and together with you, is that it is incumbent on us. So it is my appeal. We must embrace and pursue the culture of talking to one another. If we do more speaking to one another in this country and do not wait for somebody to take up arms, cause so much damage, and then we want to speak peace with such a person, we would, I believe we would bequeath to future generation, our children whom we love so much, our grandchildren who give us happiness when we go home or when they come to visit us, they're all over us. We would bequeath to them a country we are proud of. We would depart from this world knowing we left Uganda a much better place than when we found it when we took up responsibility. It's incumbent on all of us. It would be foolhardiness on us not to embrace the culture of peaceful resolution of whatever conflicts. We own this country equally. I still believe every one of us love this country equally. Even Idi Amin loved this country. His way of showing how he would protect the country was the wrong one, but he loved this country. Name any leader. Sir Edward Mutesa, Milton Obote, Idi Amin, Yusuf Ulule, Godfrey Binaisa, Obote again, Tito Okello, Yoweri Museveni. You really have to do a lot of convincing to persuade me that any one of them did not love Uganda. I'm ready to spar with you to prove to you that they all love Uganda, every one of them. But the way they thought they would keep this country as an expression of their love is the subject matter of serious, serious deliberation. So I thought the day to honor the memory of Chief Justice Benedicto Kiwanuka, it's a fitting occasion to share my views on this. That please let us talk. Let us hold conversation. Let's talk about our country. Let us seek to understand that which we do not understand. Let us respect the Constitution and the acts of parliament and the rules and regulations which are put in place. For those of us who hold positions of public positions of responsibility, those of you who have held this position and are now enjoying what my chief registrar is calling refinement, those of you who are now being refired, posterity will judge us harshly. And we must speak about this. We owe it to ourselves and posterity. Allow me to once again extend our appreciation to the family of the late Chief Justice. While we say the late Chief Justice Benedicto Kiwanuka, you should know that Chief Justice Benedicto Kiwanuka will never die. He's only been physically removed from us, but he lives with us. It's our inspiration. It's the reason why we have all spoken up here. And it is part of honoring his memory that I have called out to everyone in this country that please let us talk to one another. It costs us nothing to speak to one another. The alternative is dreadful. Speaking after arms have caused so much damage. It's a very painful thing. Chief Guest, as you know, we went to speak with Coin when I'd just come back from Bradford, where I'd done my master's in conflict resolution. And indeed, it was my involvement as minister in Northern Uganda that led me to go and do conflict resolution. And for my dissertation, I picked on this never-ending debate, the choice between justice and peace in bringing an end to conflicts, especially internal conflicts and conflicts. And I had discussed the Northern Uganda, the LRA conflict in Northern Uganda, without knowing we were going to speak about this. And when I sat with Joseph Kony for 6 hours, November 2006, at his invitation, I was speaking to him about the things I had studied, the things I had written about. And as you know, it was Joseph Kony actually who recommended that I attend the Juba peace process. Strangely, although a few years earlier, when I was appointed to replace Betty Bigombe, he had given an edict that I should be summarily executed on site. It didn't scare me because I believe in predestination. In the end, he told me that no, he countermanded that, yes, he did, but later on, which is true. I mean, intelligence informed us that he had given another order that I should not be killed. But the point I'm making is, we can speak in this country to one another. I don't think I can have an enemy whom I cannot speak to. It is not costly. It brings harmony, and that's what alternative dispute resolution, whom we have a team, including my 2 brothers who are here, are doing. Win-win situation. You come to court or you come before mediators when you can't speak with one another. You can't even share water from the same well or borehole. And by the time you go back, you now stop at a beer joint and you drink together before reaching home. Has it come back?
The wire is smoking, so
Okay.
the connection.
Okay. Okay, it's okay. Thank you. If only to honor the memory of Chief Justice Benedicto Kiwanuka, and when we talk about the honoring the Chief Justice Benedicto Kiwanuka, is representative of hundreds of thousands of Ugandans whose lives have been cut short, unnecessarily cut short. Extrajudicial executions, and so on and so forth. In a special way, I wish to congratulate the family of the late Honorable Justice Herbert Ntabugoba. Again, Justice Herbert Ntabugoba will never die. We had him speaking today through the principal judge. And that's why if you're a good judge, you'll never die, because you keep on speaking. In other words, your decisions are cited, your decisions guide future generation in conflict resolution. He was a personal friend of mine. Mama was happy to see me today. He wanted me to become a High Court judge when I was 36 years old. I told him, my Lord, I don't want to lie, I haven't lived my life. And I told him I wanted to make a decision when I was 45, whether to continue with private practice, join elective politics, or join the judiciary. Every time he would meet me and say, when are you making that decision? However, it was another judge altogether who made me a judge. Again, when I was with the guest speaker in Juba, was retired Deputy Chief Justice Seth Manyindo, who made me a judge behind my back. When I discovered, fortunately, I was way above 45 years, so it was a little easier now for me to accept. And he had tied me. The news was very tight now, I could not decline. So Justin Tabugoba, I may not be pronouncing it correctly, was won the Distinguished Benedicto Kiwanuka Award for this year, 2023. It's a most deserving awardee for the reasons that have been given. I didn't hear anybody say here that he was a workaholic. The story is told that he would tell the deputy registrar in charge of civil that bring all the difficult cases to me. At times, judges meet very difficult counsel and they send the file back. So Justin Tabugoba would say, bring them to me. Bring those counsel on. He never shied away from handling any case. And I want my brothers and sisters of the Court of Record hear this, that Justice Tabugoba never found any case too difficult for him to handle. And many times I believed that he had overworked himself and it had an impact on him. When we saw him later in life, it was pathetic, it was painful, but that notwithstanding, his name is etched in the annals of the Ugandan judiciary. He did not fear anyone, I agree, but neither did he also fear any case, which I think was more important. We stand with you, we congratulate you, and we wish you were here personally, physically, to receive this award. But we draw fulfillment in the fact that his spouse was here to receive the award. I call upon the Tabugoba family members and the judicial officers to embrace the qualities that have been brought out here about the late judge. This is our country. We must serve it with all our heart and leave a legacy which other people will stand up here tomorrow and say without fear or without favor that it is something to emulate. I thank you, my Lord, the Deputy Chief Justice, as chair of the committee that organized this function, for organizing yet another very successful function in commemorating the life of a great man. To all of you, I thank you for sparing time to come to this function. May the good Lord give you good health and a long, fruitful life. Thank you. I now take this singular honor to invite our chief guest today, the Right Honorable Ndugu Ruhakana Rugonda. Most welcome.
The Honorable Chief Justice, Honorable Deputy Chief Justice, and my brother and Honorable Deputy Attorney General, as advised by the Chief Registrar and Master of Ceremonies, protocol is observed. His Excellency Yoweri Museveni, as he normally does, would have wanted to come and deliver this lecture, but because of other important state commitments, he has not been able to do so. And he asked me to represent him. And it is therefore now my pleasure to deliver President Yoweri Museveni's message. I thank the leadership of the judiciary for organizing the 60th Benedicto Kiwanuka Memorial Lecture at the High Court grounds in Kampala. 51 years ago, these grounds were a scene of unprecedented assault against the judiciary when its head, Chief Justice Benedicto Kiwanuka, was violently abducted and murdered on the orders of Idi Amin. This was such a low moment in our country's history. This tragic memory is a clear vindication of the actions of our patriots who took the path of armed resistance against dictatorial and bankrupt regimes in post-independence Uganda. If the head of the third arm of government could be dragged from his chambers in broad daylight and summarily executed, one does not need to have extraordinary powers of imagination to guess the fate of millions of ordinary Ugandans under Idi Amin's bloody regime. What was the justification for killing the first Ugandan Chief Justice? Benedicto Kiwanuka was highly trained in matters of law. He was an experienced political leader, having served in portfolios as first Chief Minister of Uganda and also leader of the Democratic Party. This shows that he was a great national asset, given his qualifications, his experience, and his exposure. Why did Idi Amin deprive the country of the services of such a great leader? How did he hope to build the country's institutions without the input of professionals like Benedicto Kiwanuka? If there had been disagreements between Amin and Benedicto Kiwanuka, it was possible to resolve them without resorting to crude and cowardly methods. Amin did not stop with the murder of Chief Justice Kiwanuka. He targeted the elites that challenged his dictatorship, like university professors, doctors, lawyers, politicians, religious leaders, and many other individuals and groups. They were either forced into exile or killed, like Archbishop Janan Rum, who was murdered in 1977. These murders were not evidence of Amin's strength. Rather, they exposed his ideological bankruptcy. Politics is a contest of ideas on how to manage society. You cannot expect homogeneity in the political field. Democratic rule presupposes the existence of interest groups, which represent varying ideologies and different ways in management and the distribution of resources. Therefore, political opposition, if it is focused and disciplined, is good and healthy for the country. Amin's attempts to annihilate the elites did not succeed. It is these elites, supported by Mwalimu Julius Nyerere, who led the struggle which ousted Amin from power. Uganda has now emerged from the dark past of dictatorships, extrajudicial killings, poor infrastructure, economic collapse, social backwardness, etc. The victory of the guns which culminated into the NRM's capture of power in 1986 has been followed by other major victories on the social and on the economic fronts. It was therefore necessary to wrestle the guns from the hands of the rogue armies that were terrorizing innocent Ugandans and plundering Uganda's wealth. The cure, which the NRM prescribed for Uganda's problems, is contained in the 4 principles of patriotism, Pan-Africanism, socio-economic transformation, and democracy. By following this path, we have managed to stamp out the sectarianism of tribe, religion, gender, and others, which undermined national unity and national development. The NRM has managed to rally Ugandans around their common interests like peace, wealth creation, and other interests. We have reversed the situation where leaders impose themselves on the population and the political scores were settled by the barrel of the gun. Today, after 5 years, Ugandans exercise their constitutional right to choose leaders from the president to the village councils. The armed conflict in Uganda by 1986 had forced a total of 500,000 Ugandans into exile. Uganda is now a safe haven for 1.5 million refugees from other countries and has earned recognition as a defender of peace and stability, not only within her borders, but also across East Africa and indeed the entire African continent. The country enjoys better and modern infrastructure. That's the good roads, electricity, ICT infrastructure, and other things that have been done by government. These trigger socio-economic transformation by attracting investment because they lower the costs of doing business in an economy. In many parts of Uganda, the people have never seen had never seen a tarmacked road or an electricity pole until the NRM came to power. However, the NRM is telling Ugandans that development alone is not enough, though it must come first. Development is a collective good for everyone. It must, however, be translated into jobs and wealth for the families in order to be meaningful. And the NRM, the country has transitioned from being a land of shortages to a land of plenty and surpluses. We now have surplus milk, sugar, bananas, etc. As more households continue to respond to the NRM's message of enterprise selection with equivalent calculation in the 4 sectors of commercial agriculture, industries, services, and ICT, the production of industrial and agricultural commodities will go up. It is clear that our small market of 45 million Ugandans cannot support our prosperity. This is why the NRM talks about Pan-Africanism. When the NRM came to power, we lost no time in working with our Tanzanian and Kenyan brothers and sisters to revive the East African community. The community has now grown with the addition of Rwanda, Burundi, South Sudan, and most recently, the Democratic Republic of Congo. Uganda is now economically integrated to the bigger markets of East Africa and indeed of Africa. Finally, this memorial lecture of Benedicto Kiwanuka is a constant reminder that even when human life is mortal, our actions and influence, if anchored on correct ideas, can inspire generations. Today, both Amin and Benedicto Kiwanuka are long dead. However, their legacies differ. Benedicto Kiwanuka stands out as a votary for truth and justice, while his murderer, Idi Amin, will forever be associated with shame and dishonor. I thank you all for honoring the wonderful memory of Benedicto Kiwanuka. Thank you.
Thank you, and thank you so much, our chief guest. Let us give a befitting round of applause. It could be better than that. I know that lunchtime is, we've worked through lunch, but the Chief Justice has provided a meal, and so we are going to eat. Thank you so much for delivering that message of His Excellency. I believe we all go with a lot of reflections for today, including the end. The legacy is your choice on what you want to be remembered for. So we really have come to the end, but we thank God so much. He's given us a good day. He gave us soft rains that allowed to cool the tent, and we have enjoyed our function to the very end. We started with the procession and we are now at the end. Let us clap for God for giving us a wonderful function. So with that, we will be standing up to have the anthems in reverse order. We'll have a photo session right here, and then we'll enjoy our lunch and depart at leisure. I request we stand up for the anthems. Thank you very much. PRO, please come and direct us on the order of photographs.
Thank you, Chief Registrar. The Lord has indeed been very good for us today. Yesterday we had a lot of rains and today a little drizzle. We can thank God for that. Your Excellency and my Lord, the Chief Justice, allow me, with your permission, we are going to have a few photo sessions to cover all our guests. And I will request the high table, we have prepared outside there some seats because we want a very bright picture for our moments. And I will request the Honorable, the Guest of Honor, Honorable Chief Justice, the Deputy Chief Justice, Honorable Attorney General, Honorable PJ, Emeritus Chief Justices present, and the Honorable PJ present Emeritus to join us, Honorable Minister, representing the Minister for Gender, and Honorable Sabtul and our guest speaker. Please let us go and take our seats. And our moments shall be, we shall start with the family of the late Chief Justice, Ben Kiwanuka. Please let us come out and take our picture moment. That shall be followed by the family of the Honorable Principal Judge Emeritus Ntaboba. You will be next after that session. And the next session will be the members of the Judicial Service Commission present. And that session will be followed by the Judiciary Council members present. We shall also then take a photo moment. And immediately we shall have the justices of the Supreme Court and the Court of Appeal together, including our retired judges present, please. We shall be joining in that photo session. Then we shall be followed with the judges of the High Court. And after the judges of the High Court, we shall have the heads of missions present and jealous institutions and the governance, security and peace program. After that, we shall have our sitting tenants, the registrars and magistrates, who should also join in, and then we shall then have the bar also taking a photo moment, and the last will be the organizing committee. So that shall be the order, and I will request that we follow that as soon as we are picked for the photo moment. And then we shall have the justices of the Supreme Court and the Court of Appeal together. And I request also our retired judges, Honorable Justice Mugamba Kasule, to join the team. Yes, Honorable Justices of the Supreme Court and the Court of Appeal, please, can we join the team with our retired justices? As the judges of the High Court, you prepare to join the team. I will request the judges of the High Court to be prepared, come close. judges of the High Court, as our dear heads of missions and jealous institutions, you also get prepared. And the governance and security program members shall be joining in the same photo. Okay, now Betty, moderating a function. Can I call you back shortly after? Thank you. Thank you. Heads of missions, jealous institutions, and the governance and security program. As registrars and magistrates present, you equally prepare yourselves. I request that you come closer. The registrars and magistrates. And I request the members of the bar to prepare for the next photo session. And I would also request the Secretary Law Council. Secretary Law Council, you will join in with the bar. From here, we are having a lunch, and we are going to have the lunch at the upper yard. So you will be assisted and served by the protocol officers out there. The last photo will be for the organizing committee. So organizing committee, be ready for the photo moment. Let us have the photo for the bar. And the last photo will be the organizing committee. Organizing committee members, we are going to have the last photo session. Please, lunch is being served at the upper yard.